Hello, guys. Let's begin. Anticipatory bail. Now, anticipation means what? You are expecting that the you will be arrested. Okay, he has not mere expectation, but there is a reason to believe, strong reason to believe that the person may be arrested. Apprehension or anticipation. So in that apprehension or anticipation, the person files an application for anticipatory bail to the Sessions Court, High Court or Supreme Court, that stating that what is his reason to believe, what are the circumstances that are forcing him to believe that he may be arrested anytime soon, and to avoid that arrest he wants this anticipatory bail. It is not a guarantee that you will not be arrested at all, but for the time being he will be prevented from getting detained, since arrest is what, a form of detention wherein your movement rights, the right to move freely anywhere, that will be restricted, है ना, your freedoms will be curtailed. So to avoid that for a certain period of time, this anticipatory bail can be granted and the court can be approached. The first one to be approached is the court of sessions. लोएस्ट से शुरू करके हम हाईएस्ट पे जाते हैं. हम कहते हैं बेसिक कॉन्सेप्ट स्ट्रॉन्ग करो, तब आगे चीज़ें समझ में आएंगी, राइट. सो सबसे छोटा क्या है, कोर्ट ऑफ सेशन, तो उस पर जाएंगे. उसके बाद हम हाई कोर्ट, सुप्रीम कोर्ट भी जा सकते हैं फाइलिंग फॉर दिस. The court may consider following aspects when considering an application for anticipatory bail: nature and gravity of accusation, means what is the offense with which he is accused, क्या एलिगेशंस लगे हैं उस पर, उसका खुद का बिहेवियर कैसा है जेल में. एंटीसीडेंट्स मीन्स व्हाट आर द हिज पास्ट बिहेवियर, पास्ट कंडक्ट. पॉसिबिलिटी दैट ही मे फ्ली फ्रॉम जस्टिस, मीन्स he may avoid the administration or trial if he is set free on this anticipatory bail. उसको और टाइम दे दिया गया कि वो अभी अरेस्ट नहीं होगा, हमने ग्रांट कर दिया दैट हाँ he has got anticipatory bail and now he will not be arrested at present. that means अभी तो उसको हमने फ्री कर दिया और अब वो भाग सकता है, ठीक है. The accusation appears to be aimed at humiliating the applicant. Applicant is who, कौन है applicant, कौन है एप्लीकेंट यहाँ पर, अक्यूज्ड है, राइट, बिकॉज ही इज फाइलिंग द एप्लीकेशन फॉर एंटिसिपेटरी बेल. सो अक्यूजेशन अपीयर्स टू बी एम्ड एट ह्यूमिलेटिंग द एप्लीकेंट. ऐसे अक्यूजेशन लगाए हैं जिससे सीधा सिर्फ यही आ रहा है कि या तो आप डिफेम करने की कोशिश कर रहे हो या जानबूझ के उसको ह्यूमिलेट करने का तरीका है और कुछ नहीं, ठीक है. एंड दैट हैज़ टू बी इन्फर्ड फ्रॉम द फैक्ट्स एंड सर्कमस्टांसेस ऑफ द केस. Cognizable and non-cognizable offences. CRPC has not given any test to determine cognizable or non-cognizable offences. First schedule, however, indicates that all offences punishable with imprisonment of not less than 3 years are taken as serious offences. और ऊपर भी आपने ये क्राइटेरिया देखा था, 3 years serious offences क्या थे वो, non-bailable, in which since there are serious offences, so bail cannot be granted as a matter of right. ओके आपको हम फ्री नहीं छोड़ सकते क्योंकि आपने या तो सीरियस ऑफेंस करा है या फिर सीरियस ऑफेंस आप पर एलिगेशन लगा है. सो वी कैन नॉट सेट यू फ्री बिकॉज सीरियस ऑफेंस किया है, दैट मीन्स उसका कंडक्ट शो करता है कि उसके कंडक्ट में कुछ ग्रेवनेस रही होगी, कुछ ग्रेविटी रही होगी, कुछ भयंकर कांड किया होगा, ठीक है, इन कॉमन लैंग्वेज. सो दे आर सेड टू बी कॉग्निजेबल ऑफेंसेस. Offenses like murder, robbery, dacoity, rape, kidnapping, these are cognizable. See, every offense is serious, right? Offense of bigamy is punishable with more than 5 years imprisonment, yet not included in category of non-cognizable offense. Because why it is said so? Because not less than 3 years को हम serious offense ले रहे हैं and they are treated as cognizable. Over here it is more than 5 years, still it's non-cognizable. Not less than 3 years, 3 years से कम नहीं होने चाहिए. 3 years और more का punishment वाले क्या हैं, serious offenses, cognizable, okay. and non-cognizable और इसकी punishment 5 years है, तो 3 ईयर से तो ज़्यादा हो गई है, स्टिल इट इज़ नॉट कॉग्निजेबल, बट इट इज़ अ नॉन कॉग्निजेबल ऑफेंस, बिकॉज अगेन over here you have to see the gravity of the offense. Bigamy, although it's serious, it may be a serious offense, it may give wrong uh, example into the society, it may set a wrong precedent into the society, but still इस ग्रेविटी के इक्विवेलेंट ये नहीं है. इट इज़ नॉट टेकिंग द लाइफ ऑफ अ पर्सन, इट इज़ नॉट शेकिंग द सोल और द conscience of a person. Okay, then basically this was about seriousness and everything, but basically this distinction is made to arrest matters. That is, cognizable offenses are those where arrest can be made without warrant is issued by the court, and non-cognizable where arrest can be not made without the warrant of arrest warrant जिसको बोलते हैं, that has to be issued by the court. Now why is so कि cognizable offense में हमें warrant की ज़रूरत नहीं पड़ती arrest करने के लिए, although arrest is detaining the rights or curtailing the freedom of the person, because it are serious offenses. They are serious offenses, and by the time police go and apply for the warrant and the warrant is given by the court, everything in government office or every little work, small task in government office, let it be court even, it takes a long period of time. It is not granted in a matter of 1 or 2 days or 1 or 2 hours, right? So it may take a longer time, and there are chances that within that period of time the person accused flees away, he escapes, he elopes. Now what will the police do? किसको अरेस्ट करेगी वो? इतना बड़ा कंट्री, इतना बड़ा शहर, where will he find him? Accused may have gone anywhere. He may have hidden himself in his relative's house, in his friend's house, or anywhere. There are so many places to search, and it is not practicable. And even the violation of right to privacy, if policeman goes to every house to check कि यहाँ पर तो नहीं आया वो, so it is very impossible kind of thing to search for it. इसीलिए हम भागने की अपॉर्चुनिटी ना मिल जाए अक्यूज्ड को, serious offenses cognizable में without the issue of arrest warrant by the court, police can arrest the person. Okay, then we come on to compoundable, non-compoundable. The state which conducts prosecution and accused can come to an arrangement where instead of being present, the accused can pay a fine. Compoundable means which are able to be compound, and compound here refers to an agreement or an arrangement wherein both the parties, prosecution and accused, that is victim and accused, they enter into an arrangement among themselves that okay, if you want कि आपकी पनिशमेंट माफ़ हो जाए या हम आपको इतनी सज़ा ना दिलवाएं, तो आप इतना कॉम्पनसेशन या इतना फ़ाइन पे कर दो. नाउ वाई damages are not to be said here, because damages are awarded in civil cases. Criminal case का which is a wrongful act against the society or which has harmed physically or mentally a person, it cannot be equivalated into a certain amount of money. It is a grave wrongful act which is done. So that's why we use the term fine or penalty. Okay, so instead of getting imprisonment, they enter into an arrangement that you pay us this much of fine, and okay, I will withdraw the case. So in compoundable offenses, the prosecution, after making the arrangement, they have to withdraw the case. And in such matters, if that compound agreement is presented and both the parties have consented freely to it without any force or pressure from anyone, with their free consent, they have agreed that okay, we are ready for this arrangement, they have to present that agreement into the court where the case is pending, and court does not has anything to do rather than to pass a decree based on that order, that okay, I am allowing for the withdrawal of this case. Fine. Non-compoundable means which are not able to be compounded, wherein the arrangement cannot be made. Okay, and this list is also provided in the first schedule of CRPC, which are compoundable, which are non compoundable. So they have presented a long list कि कौन कौन से offenses में आप compound कर सकते हो, कौन से में आप compound नहीं कर सकते. It's not that in every offense, in rape offense you can compound it, no. In murder you can compound it, no, because life of a person has gone. Okay, so also you can refer to section 320 of CRPC for this. It provides a list of offenses which are compoundable, which are non-compoundable. Fine. Now let's see, most common example of this is where you get caught without a ticket on a bus or train and have to pay a fine. So what is there in this case? You compound, you agree that okay, please don't send me for imprisonment, but I am ready to pay this fine. So जहाँ पर लिखा होता है this much imprisonment or fine, that means you can avoid this much amount of time spending in jail by paying this much money. In this case, officer fining you is in fact compounding your offense. Of course, not all offenses are compoundable. It would not be desirable that murderers should be able to compound their offenses. But since then, it will be very easy for them to commit offenses. अरे compound तो हो ही जाएगा, arrangement कर लेंगे, पैसा दे देंगे, जान ले ली तो क्या हुआ? No, human life is something which cannot be measured in terms of money. Even while taking life assurance, money cannot be decided, because a human life for his relatives, for his friends, is so valuable that you cannot measure it in terms of money, right? Then we come on to criminal investigation and FIR, that is first information report. First information, पहली information जहाँ मिली उसकी report, ठीक है? There is a difference between complaint and FIR. Go and find it out. That's your homework. It is the information recorded by police officer on duty, given either by a aggrieved person or any other person about the commission of cognizable offense. Now, this is also very important. FIR is always of cognizable offense. For non-cognizable offense, we have NCR, that is non-cognizable report. Okay, for cognizable offense, we have first information report. Please clear out this difference, and it is a matter of concept. Don't ever anywhere say that I have filed or the person files FIR for a non-cognizable offense. No, for non-cognizable offense we have NCR. Fine. So FIR is always filed for the commission of cognizable offense, and it is filed, recorded by the police officer on duty according to the information given by the person, victim, aggrieved person, or any other person who may have seen the incident happening. Okay, statement of the informant, informant means who gives the information, he is known as informant, is recorded, and that report is known as FIR, and it is under section 154 of CRPC. Main object from point of view of informant is to set the criminal law in motion. A case law comes over here, so you have to learn it. Hasib versus State of Bihar. What is the main object of FIR? Why we are filing FIR? Why we are giving the information that this incident has happened? So that criminal law in motion. What does this mean? I have given the information that this offense is committed at this time, at this particular place. Okay, and he may be a eyewitness. He may have also seen that who has committed. Not clearly, but sketches बनवा सकता है उसके, इतना उसने देखा है. ठीक है. So time, place and person. फाइन. इसकी information ये informant जाकर पुलिस स्टेशन में दे देता है. ठीक है. Now when information is received, what is the work of police generally? To go to that place or to investigate, है ना, कि क्यों किया क्राइम, कैसे किया, और क्या मोटिव था क्राइम करने के पीछे का, किसने किया, फिर वो उस किसने को ढूंढेंगे, जाकर उसको पकड़ेंगे. सो ये क्या हो रहा है, क्रिमिनल लॉ मोशन में आ गया है, लॉ मोशन में आ गया है. ठीक है. एंड वाई क्रिमिनल? बिकॉज इट्स अ क्रिमिनल मैटर, एंड वट एवर प्रोसीजर्स और वट एवर एक्ट्स विल बी डन बाय द पुलिस, दैट विल बी अकॉर्डिंग टू CRPC. So criminal law in motion. Basically this means so that the investigation can start, and the person who has committed the crime, the object of committing the crime, that all can be determined, and the person can be punished, justice can be served, and the victim can be if he is dead तो उसके हिसाब से प्रोसीजर्स होंगे. इट विल बी लाइक ऑफेंस ऑफ मर्डर हैज़ बीन कमिटेड, सो नाउ व्हाट विल बी द पनिशमेंट, नाउ हाउ विल द प्रोसीजर्स गो ऑन for the accused. So many cases are there. Criminal law in motion means to start the investigation. Police cannot refuse to register the complaint. Now this is a practical thing, this is a very important thing. Police cannot refuse. If he is refusing, you have to report to the magistrate, you have to report to the senior police officer, okay, that he is not registering my complaint. If any person is aggrieved by refusal on part of police officer in charge of police station, now who actually registers the complaint? Not a police officer, but police officer who is in charge of the police station. And police station, which police station? जहाँ पर वो एक्ट हुआ है, दैट मीन्स एरिया जुरिस्डिक्शन होनी चाहिए उस पुलिस स्टेशन की. अगर एक्ट इलाहाबाद में हुआ है, आई हैव टू रजिस्टर द केस इन द पुलिस स्टेशन ऑफ इलाहाबाद, और इलाहाबाद के भी उस पुलिस स्टेशन में जिस एरिया में वो एक्ट हुआ है. सपोज हेयर देर इज़ अ प्लेस कॉल्ड मीरापुर. इफ़ एन एक्ट इज़ डन इन मीरापुर, देन आई हैव टू गेट इट रजिस्टर्ड, गेट द इंफॉर्मेशन और गेट द रिपोर्ट रजिस्टर्ड इन द मीरापुर जुरिस्डिक्शन पुलिस स्टेशन ऑफ इलाहाबाद. I cannot go to Jaipur to get it registered. It will be out of jurisdiction, and तब तो refusal होगा ही होगा, and that will be a valid one on the grounds of lack of jurisdiction. So everywhere a competent jurisdiction has to come into picture. Okay, he may send by post. Now what the person, the complainant or the informant can done if he is refused? He may send by post the substance of such information. Substance of such information means whatever information he has, whatever content he has, he can send that in writing. Of course it has to be a written letter or written application to the superintendent of police concerned. Section 154 subsection 3. FIR can be filed in police station of the concerned area in whose jurisdiction offence has occurred, as I told you. Now the information on refusal which he is given to SP, that has to be a written application, but FIR can be either based on a written or oral statement of complainant. Either I go and I go home, write a letter in written form and give it to the police station. That on that can also be an information piece, and on that basis he can register the FIR. Or I can give my verbal statement. I was so panicked seeing the incident happened in front of me that I quickly went to the FIR, to the police station, and on the basis of my verbal statement I got it registered. Okay, so on, but again इट डज़ नॉट हैज़ टू बी अ हियरसे कि मैंने पुलिस को बोला, पुलिस ने फिर आगे अथॉरिटीज़ को बोला कि ऐसी ऐसी इन्फॉर्मेशन मिली थी. नो, पुलिस हैज़ टू इवेंचुअली गेट इट reduced to the written form. Police eventually has to write it. Whatever he is saying, whatever the complainant is saying, that has to be written by the police officer in charge of the concerned police station जिसकी jurisdiction थी, and after that it has to be read and told कि देखो मैंने ये लिखा है to the complainant, and then both police officer and the complainant, they both have to sign below it. Okay, एंड कंप्लेनेंट के बाकी नेम और एड्रेस और ये सारी जो डिटेल्स हैं, बेसिक डिटेल्स, वो भी लिखी जाती हैं उसमें. ओके, it must be made to the officer in charge of police station, and if he is not available, assistant sub inspector is competent to enter the same. On the basis of FIR, police starts its investigation, and this is known as set the law in motion. Section 154 provides for the manner in which this has to be recorded. So if you want more such manner, if you want to see the details, you can go to section 154 of CRPC. बेसिक डिटेल्स वही हैं जो मैंने आपको बोली कि यू हैव टू रिड्यूस इट इनटू द रिटन फॉर्म, एंड देन यू हैव टू रीड इट एंड टेल दैट ये लिखा गया है आपके कंप्लेंट के बेसिस पर. कंप्लेनेंट को पढ़ के सुनाना होता है. कंप्लेनेंट उस पर हाँ या ना बोल सकता है कि नहीं ऐसा लिखो वैसा लिखो, और दैट हैज़ ऑल्सो टू बी इन अ क्वेश्चन आंसर फॉर्म. ओके, then we come on to some important facts. Information of cognizable offence can be given by any person. Why? Because it can be an aggrieved or any other person who may have seen the incident. to police having jurisdiction in the area where commission took place. FIR is not substantive piece of evidence. It is only an information of the act of crime. It is not a substantive piece of evidence. Substantive means it is not a solid proof of evidence कि ये है तो मतलब प्रूफ हो गया कि ये क्राइम हुआ ही था. No, it has to be supported, it has to be proved. Now this also has to be proved by some other thing, some other fact, some other finding by the police in its investigation, which it may have done, right? Police officer has to reduce this in writing. Informant signature must be obtained. Contents of such information should be read. ये वही सब दिया हुआ है. Copy of such information has to be provided to the informant. Original FIR has to be sent to magistrate. Despite a police officer refusing, aggrieved can send such information to SP by post. FIR is to be made immediately after the occurrence of incident when the memory of the person giving it is fresh in his mind. Because as the time elapses, it may happen that you forget what has actually happened, right? So there may be some tickles in the memory. So when the memory is fresh, जब आपको ताज़ा ताज़ा याद है वो चीज़, तब आप उसको बता दो कि ऐसा ऐसा हुआ था. Telephonic information is said to be a cryptic information, okay, and it can also constitute FIR, which properly discloses the commission of cognizable offense. Mere cryptic information, ऐसा ऐसा गए थे हम, ऐसा ऐसा हो गया, पुलिस ने पूछा कौन बोल रहे हो, तो नहीं बताया कि कौन बोल रहे हैं, कहाँ हुआ वो भी नहीं बता पा रहा. So that is very vague information. It cannot be an FIR. You have to give proper information about the commission of crime, area, and what all has happened. Government has formulated provisions of zero FIR. Zero FIR means, like, generally FIR has to be filed in the place where jurisdiction is, where it is competent jurisdiction according to the area where act was committed. But in cases you cannot go to that jurisdiction area, or you don't know the jurisdiction कि कहाँ पर fall करती है, you are in a new city, you don't know कि jurisdiction क्या है क्या नहीं, तो आप किसी भी FIR, किसी भी पुलिस स्टेशन में जाकर FIR रजिस्टर करवा सकते हो. And then it is the duty of that police station's police officer in charge to transfer that FIR to the competent jurisdiction police station. Okay. Victim can file his complaint in any police station for any offence for a quick action, and the case can be transferred to the concerned police station thereafter. Concerned police station means the one which has competent jurisdiction in the matter. Information to the police as to non-cognizable offence, that is NCR, which is section 155 CRPC, provides that if any person gives information to an officer in charge of a police station of commission of non-cognizable offence, he shall enter or cause to be entered, means either he enters himself or he asks some other subordinate officer to enter the substance of information in a book prescribed for this purpose. Book prescribed for this purpose is called NCR diary. Okay, police officer has no further duty unless magistrate directs him to investigate the case. Now non-cognizable offence में तुरंत law is not set into motion, but it has to be done on the directions of magistrate. Even arrest has to be done on the direction of magistrate in a non-cognizable case, right? So investigation start करना तो दूर की बात है, and they are not the more graver or serious offences as the cognizable cases are, right? So police officer has no further duty than to register the case, to register the information of commission of non-cognizable offence. Whatever further he has to proceed, that has to be done on the directions issued by the magistrate. Generally speaking, non-cognizable offences are more or less considered as private criminal wrongs, means against, like defamation, मेरे और उसके अगेंस्ट ही होगा, not grave to be considered as against the whole society. Murder, rape, these are grave offences. The basic rule is that no police officer shall investigate non-cognizable case without order of a magistrate having power to try such a case or commit the case for trial. Commit means to send it to the higher court, okay? Because that magistrate also may not have the powers to try the case. Basically it means that जितनी उसकी jurisdiction है of giving the punishment or fine, वो केस, वो offence उस punishment से ज़्यादा carry करता है. Like if a magistrate has power to try offences of 1 year, offences having imprisonment of 1 year, but a case comes to him since he was area magistrate to try a case of offence which is imprisoned, which is having punishment of imprisonment 3 years. It is beyond his jurisdiction, he cannot try, so he will commit the case. Okay, that is the meaning of commission. Then to try a case means to do trial. Try means to do trial. After investigation, inquiry stage, we come on to the trial stage, and after the end of this trial stage, the decision is passed by the judge. Okay, so basic rule is that no police officer shall investigate without the order of magistrate. और कौन सा magistrate? जिसका jurisdiction है उस matter को try करने का. ठीक है. In a situation where criminal case consists of both cognizable and non-cognizable offences, हो सकता है ना कि एक series of act में उसने 2-3 offences किए, जिसमें से एक offence आ गया cognizable, एक हो गया non-cognizable. ठीक है. Case shall be deemed to be cognizable case, notwithstanding that other offences are non-cognizable. Because if one serious offence has been done in that consequence or that series of act, that means the whole series of act will be considered to be a serious one. So it will be considered a cognizable case. Okay. Then we come on to, see, we are saying what? We are saying it will be considered a cognizable case. We are not saying it will be considered as a cognizable offence. Offence का nature change नहीं होगा. But in that series of acts, since he has committed more than one offences, out of which one is cognizable, even one is cognizable. 4 offences किए, 3 नॉन कॉग्निजेबल थे लेकिन एक कॉग्निजेबल है. इवन इफ दैट वन इज कॉग्निजेबल, द होल केस विल बी सेड टू बी अ कॉग्निजेबल केस. Okay, and then जो भी powers होंगी पुलिस की, that will be according to as if they are trying originally a cognizable offence. Fine. Now arrest and rights of a arrested person, next video.